Doesn't look like there's going to be a political involvement, at least not from the White House, and at least not at this point. And so here we are at the 11th hour. That means Ottawa has now filed court documents asking an American judge to stop that planned shutdown of Line 5, or that ordered shutdown. Seamus O'Regan is the Minister of Natural Resources. Minister, lots of meat to get into the discussion, but just a brief question for you first. We are now just a few hours away from Michigan's deadline. At that point, is there any risk the taps will somehow be turned off?
We don't believe so, no, David, we don't. We believe that, level heads will prevail here. We also strongly believe in the court and the mediation process. So what we did today by filing an amicus brief basically means a friend of the court. I mean, the dispute itself is between Enbridge and Michigan. But we clearly have an interest, and we have information that we believe is relevant to the dispute. So we wanted to wait until now, so we had a clear view on all events that have transpired. And now is the time to make the court aware of our interest and of this information, which basically is, look, there's a treaty that we have, a pipeline treaty dating back to 1977 that we have with the United States. It applies here to Line 5, and Michigan should not be able to unilaterally close the line. The federal court, we believe, has jurisdiction here. And in the event that this mediation fails, the federal court should not order it shut before the U.S. and Canada had a chance to work out the matter through the provisions of that treaty.
Okay, and I want to talk, Minister, I want to talk a lot about that treaty, but if I can.
Yeah, sure.
Michigan invoked, or rather issued this order 6 months ago. Here we are now, hours before that order takes effect. Why was it left until today for Canada to enter the legal case?
Well, we wanted to make sure that all parties had exhausted all options before them. We wanted to make sure that when we filed the brief, we had the absolute latest information and had prepared for any eventuality. I had said it repeatedly in the House that we were waiting for precisely the right moment strategically before intervening. Now is that moment.
Why? I mean, why now as opposed to, say, a month ago when 17 state leaders in the U.S. filed their own amicus brief and supported Michigan's case? Why did we wait until after them?
Well, just in case anything happened between that point in time and this point in time. As it turned out, not a whole heck of a lot changed, but something could have. And so we wanted to make sure that we were prepared and had that held into account.
It does not seem as if the Biden administration is particularly engaged on this. We heard from the White House press secretary today, basically said this is an issue for the courts. It's not really for us. What does that say about your own government's attempts to sort of lobby and raise this at the political effort level?
Well, first of all, I think it's important to remember too that this is we want this decision arrived at locally. We want it arrived at in Michigan in the district court. We want it, this is between Enbridge and the state of Michigan,
and but, now Canada
said,
and a bunch of other U.S. states.
Because there was national interest here.
Yeah, and
there clearly is national interest for us. Beg your pardon?
Well, I do want to look at that 1977 treaty because it's amazing to read. It's typewritten. It just seems from 44 years ago. I am struck by it because Canada's contention is essentially that the treaty applies and that neither the U.S. nor Canada can hinder the movement of oil and gas, and in this case, Line 5, bringing that oil and gas not just into the United States, but also back into Canada. And yet there is this other brief out there, other opinion rather, that says, no, the treaty actually allows for this very thing, that the treaty says very specifically that there is when there is a need to temporarily to reduce or stop for safety or technical reasons, there is an argument being made that environmental concerns are part of that. And I wonder what Canada's concern is that this exemption which exists in the very treaty that is at the basis of our legal argument, whether we are concerned about that exemption.
Well, I will offer an answer, I guess, more or less as the client or the people of Canada, the client. I'm a representative of them, as opposed to a legal opinion. I don't have a law degree. I would say that the Pipeline Transit Treaty says that look, neither country nor states or provinces within said countries should interfere with the operations of a pipeline passing through that country en route to the original source country. So, this is it's not like an export pipeline. This is a pipeline, in our national interest, going from one end of the country to the other, but it does go through Wisconsin, does go through Michigan. The other thing I would offer is that the Pipeline and Hazardous Materials and Safety Administration, which is the regulatory body that oversees a pipeline such as Line 5, has consistently assessed it and said it is safe. Their most recent assessment, I think, was in 2020. We believe we have a strong case here. We believe that we're asserting ourselves properly, and we needed the court to know that we consider this in our national interest.
Of course, critics will say that anything is safe until it's suddenly not, and they would point to pipeline ruptures, which, albeit are rare, but when they happen can have devastating consequences. And I look at a pipeline that has been around for 68 years, and certainly over the past decade has faced some resistance, and that grew into political resistance. And then we saw the Michigan governor coming out and saying, I order this to be shut down. It was just sort of the latest installment in this story. Do you think that Canada was sufficiently prepared for this moment? Should we not have acted sooner in the face of environmental and political resistance on a 68-year-old pipeline that has become contentious?
Well, I think it's important to note, too, that the permitting has already begun on a significant improvement to the pipeline where it goes underneath the Straits of Mackinac. That it would go as it is right now, and I think most people watching know this, but it's on the lake beds, so there is a concern about its vulnerability. And this would encase it in concrete and put it underneath the lake bed, therefore improving its safety and perhaps lessening the chance of any sort of interference, like a wayward anchor coming around and hitting it, or something like that. So I think that is significant. The state of Michigan continues to permit those improvements, and the U.S. Army Corps of Engineers has already permitted the tunnel. So that's an important development, which shows that the company takes, I think, the safety of it seriously, and I think it's clearly an acknowledgement that there are concerns and they should be tackled.
So a special parliamentary committee actually recommended that you have a contingency plan in case you aren't successful in this legal case and the order is upheld and the pipeline is shut down. Do you have a contingency?
Well, I think it's fair to say that we feel very confident about where things stand, about where this stands right now.
That sort of sounds like you don't have a contingency.
No, it's not. It's not to say that. The company has been working on a contingency, and we've been speaking with them about what we would do in order to make sure that those supply lines remain intact. I guess I'm just not the type of person who likes to acknowledge defeat, especially in everything that I've read. That I feel very, very confident about this case, and I feel very confident about our case.
Minister O'Regan, thank you very much for your time this afternoon.
Thanks, David.
Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.